So let's start from the very basics. A set or a system of rules and regulations enforceable by the social and governmental institutions to regulate the behavior of public is what we call as a law. Now, there is no predefined definition of law, or there is no categorical definition of law which everyone agrees to. Everyone is having their own meaning and their own interpretation of law. So John Austin, a very renowned English legal theorist, says that law is a command by the sovereign backed by the threat of sanction. Now, primarily, law can be divided into two types. So broadly, there are two classifications of law. Definitely, there are other classifications to it as well, but broadly, it can be categorized into two, that is civil law and criminal law. So civil law, which is also known as common law, deals with matters like property, housing, marriage, contract, divorce, custody of child, and other legal matters. Now, there is criminal law, which is also known as penal law. It deals with issues of crime and its punishments, which includes theft, robbery, kidnapping, murder, rape, and other criminal activities. So broadly, there are two, that is civil law and criminal law. Now, this discussion would center around the three new criminal laws which came into force on 1st of July 2024. Hello, my name is Preetpal Singh, and today's topic is the new criminal laws 2024.
Three new criminal laws will come into force on Monday. The new laws will replace the British-era Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act.
It's a big day here in India because a new set of laws has been rolled out. Laws that affect every Indian citizen.
India will replace its colonial-era criminal laws with a set of three new penal laws. They are called the Bharatiya Nyaya Sanhita or BNS.
Now, the procedural law for the civil cases in our country is the Code of Civil Procedure, that is CPC 1908. Similarly, there are three other laws in relation to the criminal activities which existed before 1st of July 2024. They can be divided into three types of laws. One is substantive law, second is the procedural law, and third is the evidence law. Now, substantive law, it basically defines the nature of criminal activity and makes it punishable. Second one is procedural law. It basically governs all the procedural aspects of the criminal cases, that what will be the procedure which will be followed while pursuing a criminal case. And third is the evidence law, which deals with the nature and admissibility of certain kind of evidences. So it basically relates to the evidences in the criminal cases. Now, earlier, before 1st of July 2024, there were three different laws: substantive, procedural, and evidence-based. Now, what were these laws? The substantive law was the Indian Penal Code, that is IPC of 1860. The procedural law was the Code of Criminal Procedure, that is CrPC of 1974. And third one, the evidence law, was based on the Indian Evidence Act of 1872. Now, one thing which we observe here is that all these laws are very, very old. And now, since the nature of the crime has evolved, definitely there was a need to replace the old laws and completely overhaul the system with a new set of laws. So, replacing these three laws, there were a new set of laws which came into play. So this IPC, Indian Penal Code, was replaced with the Bharatiya Nyaya Sanhita 2023. This Code of Criminal Procedure, CrPC, was replaced by the Bharatiya Nagrik Suraksha Sanhita 2023. And this Evidence Act of 1872 was replaced with the Bharatiya Sakshya Adhiniyam 2023. So now, these three laws will basically govern the criminal justice system of our country. And these three laws will be the primary laws in relation to the criminal activities in our country. Now, what we need to understand here is that what were the key reasons because of which we have to come up with these new laws? And what are the aims and objectives of these three new criminal laws? So basically, what was the requirement of new laws? And also, what were the concerns and challenges prevailing with the existing laws? This will be understood. Now, the first very prominent reason for introduction of these laws was to shift the colonial era punishment system to a justice-based approach. For example, this IPC, Indian Penal Code, was formulated on the recommendation of the First Law Commission of 1834, which was formed under the 1833 Charter Act under Thomas Macaulay. So these laws basically reflected the colonial mindset and the colonial legacy, which was based on oppression, punishment, and rule. And the entire objective of those laws were to ensure paramountcy of British in India, which is why it was very, very necessary to replace those older laws and replace it with the new laws which are Indian, which reflects the Indian mentality, which reflects the Indian attitude. Now, second very pressing reason was the changing nature of criminal activities. Now, activities have surrounded these days around the cyber crimes. which is a new type of crime. Different other crimes related to the Bitcoin, related to cryptocurrency, digital-based crime and digital warfare are there prevailing in the current times, which is why there is a requirement for new set of laws. Now, definitely we were amending the previous laws regularly, but how far we can keep on going on with the torn clothes by stitching and reusing them? Better to buy a new cloth so that it reflects the new age mentality and the new age attitude of contemporary India. That is why these laws were very, very essential. And this makes us go to the third reason, that the older laws were outdated, rigid and non-reflective of the contemporary Indian society and contemporary Indian realities, which is why there was again a pressing need for introduction of new laws. Also, the fourth reason was to modernize the criminal justice system of our country, to make it more responsive, to make it more efficient and effective for the common people. Also, one more objective was to reduce the ambiguities and loopholes which were already there in the pre-existing system, which is why again new laws were essential. Now let us try to understand these three new criminal laws, how they are different than the previous ones, and what are the positive aspects of these three laws. Now, as we all know, that the recommendation for these laws were given by a committee which was formed by the Ministry of Home Affairs. It was the Committee for Reforms in Criminal Laws, that is CrCL, which was formulated in the year 2020 under the chairmanship of the Vice Chancellor of NLU Delhi. Now, based on the recommendation of these committees only, three prominent bills were introduced in the Parliament of India. And based on that, these three new laws came into force. Now let us try to understand each law one by one. Let us start with the Bharatiya Nyaya Sanhita 2023, that is BNS 2023. Now this Bharatiya Nyaya Sanhita is having close to 358 sections. Earlier in IPC Indian Penal Code, there were close to 511 sections. So they have been replaced by the 358 sections of the Bharatiya Nyaya Sanhita. So several of the sections which have been struck down by the Supreme Court or the other courts earlier, they are removed. Several new sections are introduced and there have been renumbering of several other sections as well. Now this Bharatiya Nyaya Sanhita has added several new offences in relation to criminalizing the deceitful promise of marriage or criminalizing sexual intercourse under the false promises of a marriage, employment or any other identity is also a part of this Bharatiya Nyaya Sanhita. It also includes stringent provisions in relation to mob lynching and gang rapes as well, and it has also included the organized crime and terrorism under its ambit. Now it also criminalizes the attempt to suicide and also includes community service as a form of punishment under the Bharatiya Nyaya Sanhita. Now also the focus on national security is very high because of inclusion of organized crime and terrorism under the ambit of the Bharatiya Nyaya Sanhita, which is why it is focusing a lot on national security aspects as well. Also, there have been several deletions under the Bharatiya Nyaya Sanhita. First is the section 377 of IPC, which criminalized homosexuality. It has been completely repealed under the BNS 2023. Also, the provisions related to adultery have been repealed and the laws have been modified in a way as to bring gender neutrality in those laws. So gender neutral laws have also been introduced in this BNS 2023. Now other modification includes provision of fake news, that is criminalization of publishing false and misleading information. Also the sedition law have been changed to Deshdroh from Rajdroh, and also there have been a wider definition of this Deshdroh. So sedition law basically has not been repealed, but its name has been changed. So many people say that it is basically the old wine in a new bottle. Now we are yet to see that what will be the implication of these laws in the coming legal cases and the court cases. Now coming to the second law, that is Bharatiya Nagrik Suraksha Sanhita BNSS 2023. Now the first change is in relation to the technological integration. Since India is a digital economy, inclusion of technology, inclusion of new tech and high tech in the criminal cases in the law is very, very essential. Which is why this BNSS has incorporated digital technology to the fullest. Whether it be electronic FIRs, EFIRs, whether it be electronic charge sheets or electronic case diaries, digital integration in the law has been done under the BNSS 2023. Basically, it aims to reduce the paperwork, minimize the wastage and maximize the efficiency and effectiveness of our criminal justice system. It also aims to increase the accessibility and transparency of the criminal justice system. Now this BNSS has also formalized the system of a zero FIR. That means the FIR can be registered at any place irrespective of the location where the crime has been committed, regardless of the jurisdiction, and it mandates transfer of the FIR to the respective station in 15 days. Now this will be particularly crucial and very, very important for serious crimes, crimes which are having heinous nature and serious nature. Now third prominent change change under the BNSS is in relation to the videography of search and seizure. Now basically to prevent tampering and to ensure transparency, videography of search and seizure procedures carried out by the police forces is very, very essential, and this law mandates it. Now this will definitely improve the public trust and accountability on the criminal justice system of our country, which is very, very important, because if people don't trust the criminal justice system, the purpose of it is defeated. That is why this law is very, very crucial. Also, there are several provisions in relation to speedy trials and provision of fast-track courts as well to ensure timely and speedy justice to the people. Now, measures to expedite trials basically includes stricter timelines for the investigation for the cases, establishment of fast-track courts for serious and heinous offences, and provision of summary trials for minor offences. So, in this BNSS 2023, electronic records will be having the same legal status as the traditional documents, and it also allows oral evidence to be given electronically. So digital push in this BNSS can be seen very prominently. And the third law is the Bharatiya Sakshi Adhiniyam, that is BSA 2023. Now this Bharatiya Sakshi Adhiniyam, BSA 2023, also incorporates digital technology in the evidentiary framework. So it has basically modernized the evidentiary framework in our country. So basically it has expanded the definition of evidence and has also included digital and electronic forms of evidence, which are again now permissible in the court of law. It addresses the admissibility and handling of such evidences with specific guidelines and specific provisions. Also, the second part is a huge emphasis on forensic science. With the establishment of National University, forensic capacities will be enhanced by producing thousands of forensic experts produced annually. This is expected to improve the quality and reliability of forensic evidences in our country. Now, the overall approach has been shifted towards a victim-centric approach and also justice-centric approach, whereby the provisions have been made in such a way that it will lead to the protection and safeguarding of the victims. Now, this includes mandatory video recording of statements, especially in the cases of sexual offences and sexual abuses. Also, regular updates on the status of complaints by the victims. So, if we have to see the positive aspect of these laws, they are basically victim-centric, justice-centric, and the approach is very, very humanized. And also, it has incorporated modernization and technological integration into the laws. And also, social concerns and humanitarian approach can be seen with these three particular laws. But that does not mean that everything is good with these laws and everyone is very happy with these laws. Definitely, there are certain challenges, there are certain concerns which people from different quarters, whether it be legal jurists, whether it be advocates, whether it be professors or other stakeholders, they have also pointed out that there are certain challenges in the enforceability and implementation of these three criminal laws. So let us try to understand the challenges one by one, and eventually we shall know the way forward. The first prominent criticism which is given is the potential of abuse of police powers and giving excess powers to the police. Now this can be seen while the custody length. Now one of the significant criticisms is the extension of police custody from 15 to 60 days. This, many people say, might lead to police excesses, might lead to abuse of power by the police potentially, and it is seen by many as increased opportunity of police torture and also police excesses and wrongdoings, and it can also lead to misuse of power according to different quarters. Now, advocate Colin Gonsalves has said that these provisions could make these laws more draconian than the colonial era laws which these new laws seems to replace.
How the laws enacted by this government are 10 times more draconian. First, in British period, you could keep a person in police custody for a maximum of 15 days. This limitation was put because torture takes place in police custody. Now that 15 days has been extended to 90 days and more. That's a shocking provision enabling police torture.
Now, second prominent criticism is given with respect to ambiguity and uncertainty of these laws. Now, many people say that it includes vague sentences like compromising the sovereignty, unity and integrity of India. Now, many people say that this can be used to silence dissent, to curb dissent, and also to target particular groups or particular set of population. And many human rights activists say that this can be a threat to human liberty and human dignity as well. Now, third prominent criticism or concern is in relation to implementation and execution of the laws. Now, many people say that the practical implementation and execution of these laws are very difficult. Now, several provisions like mandatory videography of police procedures and several other provisions means that the police should have the necessary infrastructure, which is not very likely. And definitely police is short on funds funds and police is short on resources. So many people point out, or many experts point out, that there should be proper infrastructure, digital, physical and other type of infrastructure as well, so as to ensure that these laws can be implemented properly and effectively. Now, fourth major concern is in relation to the sentencing policy and the uniformity cause. Now, many people say that this is a missed opportunity because these laws, they do not have a uniform sentencing policy of the crimes. And many people say it is a missed opportunity. Why? Because we could have had a uniform sentencing policy which could have made our criminal justice system more equitable and more just, and which could also have brought some consistency in the justice system of our country. Now, many opposition leaders from different quarters have also criticized these laws, saying that these laws were passed without much deliberation and discussion in the parliament. Now, while these laws were being passed, close to 140 members of parliaments were suspended from that particular session. So many prominent politicians and MPs say these laws lack proper discussion and discourse, which is very, very essential to make a law meaningful and effective. Now, Upendra Bakshi, a legal scholar, has said that these laws do not particularly address the historical injustice perpetrated by the British, and suggested that the comprehensive overhaul of the criminal justice system is required. Not just the laws, but how the police functions and how the courts function, that is also required in order to ensure that the colonial legacy is left far behind and we are making laws and we are making a criminal justice system which is Indian and which reflects the Indian contemporary realities and society. Now, Justice Madan Lokur, who's a former Supreme Court judge, have also criticized the lack of public consultation while the drafting of these new laws were done, and suggested that a wider public consultation, public discourse should have happened when these laws were coming into force and these laws were being framed. Also, deeper consultation should have happened with the legal fraternity as well. However, a counter argument has been given by the Honorable Home Minister, saying that wider consultations from the legal fraternity, from the colleges, from the universities, from the advocates, from Supreme Court judges, from High Court judges, from MPs, MLAs, different states have happened, and they have given the numbers to it as well, that how many states submitted their responses, how many High Courts submitted their responses, how many governments submitted their responses. Now, while these new criminal laws have received criticism and concerns from different quarters, but still it is a landmark and a watershed moment in the history of our country and the history of criminal justice system in our country. And as our Honorable Chief Justice of India, D.Y. Chandrachud, have rightly said that these laws, in a sense, reflects a watershed moment in our country.
With the enactment of these three parliamentary legislations, India is set for a significant overhaul of its criminal justice system. The Bharatiya Nyaya Samhita, the Bharatiya Nagrik Suraksha Samhita, and the Bharatiya Saksha Adhiniyam will, as we all know, replace the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, of course, which was preceded by the CrPC of 1898, and the Indian Evidence Act of 1872. These laws, in a sense, are a watershed moment for our society, because no law affects the day-to-day conduct of our society like the criminal law.
Because no other law affects the day-to-day life of our society than the criminal law. And he also remarked that the criminal law reflects the moral arc of a society, moral arc of a nation, and is also having the ability of depriving people of its cherished liberties, which is why criminal laws are very, very important. He also said that the underlying justification in the substantive provisions is the age-old principle, which is best summarized in the saying that your right to swing your arm ends where the other person's nose begins. He also stated the necessity of infrastructure development in the criminal justice system so as to ensure that the applicability and enforceability of this law can be effective and efficient, and also to ensure that these laws are having positive impact in the society as a whole. Now, with continuous focus on implementation and stakeholder engagement, we will definitely make our criminal justice system more modernized and more representative of the contemporary realities in India. And also, as we all know, what really matters is that justice is delivered or not. So overall, the motive of any criminal justice system of any country should be entirely focused on justice and also timely justice. So all our efforts should be concentrated and surrounded on this principle only. As we all know that justice delayed is justice denied. So these three laws will definitely have a positive role to play in the timely and speedy justice provision in our country. I hope you gained a new perspective from this session. What are your opinions surrounding these three laws? Do let me know in the comment section. I'll be very happy to read them. All the very best and have a very nice day.